Good morning, everyone. I'm Jane Fielding and I'm head of the Employment, Labour and Equalities team here at Gowling in the UK. And I'm delighted to welcome you to this, our first TUPE Club webinar of 2022. So today we're going to be focusing on the information and consultation aspects of TUPE with a particular focus on measures, which is a frequent source of questions and confusion for clients in the TUPE area. It's not entirely clear always what is a measure and what you do about it if you identify one. So we thought we would cover that today and hope to remove some of that confusion and give some clarity. So our speakers are Rebecca Jones, who's a Principal Associate in the Employment team, and she's going to set the scene with an overview of information and consultation obligations and what a measure actually is, or what it's defined as. I'm then going to go through some practical scenarios and you'll have the opportunity to take part in a few quizzes to test your own knowledge and understanding. And then I'm going to hand over to Liz Wood, who is a Principal Associate in our pensions team with a particular interest in the crossover between employment and pensions, and she does a lot of work with us in TUPE. So pensions is a frequent cause of questions in TUPE scenarios. And Liz is going to cast some light on that in the context of measures. So we're going to leave some time at the end for questions, but we will finish at 11:15, so you can all get on with the rest of the day. If we don't manage to get through all of the questions and we don't pick up one of yours, don't worry, we will come back to you afterwards. As long as you leave your email address so we know who's asked the question, we'll be able to follow up with you, so you will get an answer to it. If you want to pose a question, please use the Q&A box. It's in the bottom middle of your screen. Just post a question on there. We'll keep an eye on them as we go along and pick as many up as we can. If you have any technical difficulties, please use the Q&A box as well. Susie Barnes, who's our technical support today, will try and do her best to sort you out, but hopefully we won't have any issues. And I'll mention it again at the end, but we will circulate by email afterwards a feedback questionnaire. It only takes a couple of minutes to fill in. We'd be really grateful if you would do that so that we can shape future sessions with your feedback in mind. So I will go mute and hand over to Rebecca.
Thanks, Jane. Well, I wanted to begin by taking a quick look at the framework for the information and consultation process to provide some context for the more detailed discussion that we're going to have around measures. The duty to inform and consult is a session in its own right, and today we really want to drill down on measures. So what I'm going to do for now is just focus on the aspects of the duty at the point where measures comes into play. We won't look at all of the ins and outs of the consultation process, but do let us know in the Q&A box if a more general session on that duty would be helpful. Now, the first thing I want to look at is the concept of affected employees. When we're talking about the duty to inform and consult under TUPE, what we're actually talking about is the duty to inform and consult with representatives of affected employees. And affected employees for these purposes means employees engaged by either the transferor or the transferee who may be affected by the transfer, or importantly, by measures taken in connection with the transfer. Now, it's usually fairly straightforward to identify the employees who are in scope to transfer and therefore affected for that reason. But the duty is wider than this, and we can see that an understanding as to what measures will be taken is key to determining the extent of the consultation to be carried out. In particular, whether there are any measures envisaged by either the transferor or the transferee which will affect employees who are not in scope to transfer. And in most cases, it will only be the transferee who envisages taking measures, and only in relation to the transferring employees. And in those circumstances, the duty to inform and consult will primarily be a matter for the transferor. And the reason for that is because the transferor is the employer of the transferring employees at the point where the consultation process is carried out. However, if the transferor also envisages taking measures in relation to employees who are not in scope to transfer, then the consultation process will need to involve those individuals as well. And an example of that could be where the transferor is carrying out a reorganisation to better align job roles with any transferring functions, which means that some non-transferring employees will see changes to their roles. In that scenario, the transferor then has a duty to consult with those individuals. And similarly, although it's quite unusual, there could be a situation where the transferee needs to run its own consultation process. And an example of that could be where the transferee is proposing redundancies after the transfer, which will mean pooling its existing employees with the transferred workforce. And the next thing that I wanted to come on to is the duty for the transferee to notify details of its measures to the transferor. Now, we saw on the last slide that the transferee could be subject to a duty to inform and consult with its own employees. But as I said, that's not something that's commonly required and certainly not something that happens very often in practice. But where the transferee is usually involved is in relation to the duty under Regulations 13.4. Now, Regulation 13.4 imposes a duty on the transferee to provide information to the transferor about the measures which it envisages taking in relation to the transferring employees in connection with the transfer. And as we'll see shortly, this is usually what's going to be at the heart of the information and consultation process. So in a moment, we'll move on to have a look at the detail of what a measure actually is. But before I do that, I'd just like to touch on the different stages of the information and consultation process where the measures come into play. So firstly, it's important to understand that the duty to inform and the duty to consult under TUPE are two separate things. There are a couple of circumstances where there might be a duty to inform only, so no requirement for consultation. And the first of those scenarios is where the employer has given the employees an opportunity to elect representatives, but they haven't done so. And then the second scenario, which is directly relevant to today's session, is where the employer who is consulting does not envisage any measures itself. Now, it's rare to find a scenario where there are no measures at all, but there is a point to be aware of, which could mean that there's no obligation for the transferor to consult, even though the transferee envisages taking measures. And I'll come on to the detail of that in just a moment. But first of all, if I turn to the next slide, we'll have a look at what's covered by the duty to inform. So this slide sets out the various categories of information which is required to be provided under TUPE. And that includes some basic information about the transfer, including the fact of the transfer, the reasons for it, and also the expected timing. But the real crux of the duty, which we're focusing on today, is the requirement to provide information about measures which an employer envisages taking in connection with the transfer. And there are two parts to this duty. So firstly, the transferor must provide information about any measures which it envisages taking itself, or confirm that there are none. And then secondly, the transferor must share the information that the transferees provided under Regulation 13.4 in relation to the measures which the transferee envisages. And again, it needs to confirm if there are none. So that's the duty to inform. In most transfers, there will also be consultation. Now, the duty to consult is triggered where the employer of affected employees envisages taking measures in connection with the transfer. And if we look very closely at that, we can see that the duty to consult under TUPE is actually quite narrow. So it only applies where the employer who is consulting actually envisages taking measures itself. And as we've seen so far, in most cases, it'll be the transferor who is informing and consulting with the transferring employees, but it's going to be the transferee who's the party that envisages taking measures. And what that means is that although the transferee has to notify details of those measures to the transferor, under TUPE, the transferor isn't actually obliged to then carry out consultation about the transferee's measures. Though having said that, in the vast majority of cases, that's exactly what will happen. So the transferee will notify its measures to the transferor, and the transferor will then share that information with the employee reps and then facilitate consultation with the employee reps about the transferee's measures. And a key reason as to why that happens in practice, as well, of course, as the fact that employers generally want to do the right thing by their employees, is that the tribunal has held that the information and consultation process has got to allow a period of time for voluntary consultation, even though the duty to consult under TUPE isn't triggered. And for those that are interested, that was the finding in the case of Cable Realisations Limited and GMB Northern. The last point to mention here is that where there is a duty to consult, the requirement is that consultation must be carried out with employee representatives with a view to reaching agreement about the proposed measures. And that's really going to be the crux of the consultation process, regardless of whether that consultation is carried out under TUPE or on a more voluntary basis. the focus of the consultation is generally going to be around the measures. And as a final point, before we get stuck into the detail of what a measure actually is, I just wanted to touch on why it's important for both parties to make sure that they comply properly with the respective parts of that obligation. And the main risk under TUPE is that there's a penalty of up to 13 weeks' pay per employee in relation to a failure to inform and consult, and that liability is joint and several between the parties. There's a special circumstances exemption, but it's very difficult to come within that, and I'm not going to go through the detail of that one today. It's also common for liability to be apportioned under contractual indemnities, and that can be either directly between the transferor and the transferee, where there's a direct contractual relationship, or via a chain of indemnity involving the customer of services, where the transfer is happening between two contractors. And where that happens, the party who is at fault usually has to indemnify the other party for any liability incurred if the employees or their representatives bring claims. And lastly, of course, it's better for the employees and for everybody involved if everything happens as it should and we have a smooth transfer process. So now we've got the context around the framework for the consultation process, we'll move on to take a detailed look at what exactly we mean by measures. I'll give you a bit of an introduction, and then Jane's going to take us through some specific examples, and there's also going to be an opportunity for you to join in with some polls. So we've seen that the duty to inform and consult is triggered where the employer envisages taking measures in connection with the transfer. But what exactly do we mean by measures? Well, unhelpfully, there's no definition under TUPE to help us identify what a measure is. And that means that we need to look to case law. And the message that comes out loud and clear from case law from the tribunals is that measures is given a very wide interpretation. In fact, it will cover any action, step, or arrangement which is taken in connection with the transfer. And as measures has such a wide meaning, it's important for an employer to carry out a detailed assessment of the current arrangements in order to identify potential measures so that it can notify the necessary measures. And we'd recommend that, as well as looking at the more obvious things like terms and conditions of employment and if there are any plans for any redundancy or restructuring, the transferee should also look at discretionary benefits and also more general working practices to make sure that it's identifying anything that's going to change in connection with the transfer. And one point to note on that, of course, is that when drawing up measures plans, the employer will need to bear in mind the extent to which TUPE might prohibit it from implementing measures that it would otherwise like to do. So, for example, the transferee can't simply decide to harmonise terms and conditions of employment because that's then going to be void under TUPE. So in a moment, Jane's going to run through some specific examples in relation to the guidance that we can take from case law. But before she does that, there are 2 points that I just wanted to pick up on as to what is meant by envisaging. Now, an employer must inform and consult about the measures which it envisages taking, but what exactly does that mean? Well, this has been considered in case law, and it was held that envisages simply means visualises or foresees. And in short, the employer must have some definitive plan or proposal in mind. So mere hopes or possibilities won't be measures. Now, as I said, we'd always recommend that a transferee carries out a thorough assessment of existing employment terms and discretionary benefits and also other working practices to identify potential measures so that those measures can then be communicated to the employees. The reason for that is that being clear about measures at this stage is likely to lead to a smoother transfer process and better employee relations in the long run, as well as being a requirement under TUPE. Interestingly, however, there's no positive obligation under TUPE for an employer to carry out such an exercise or even to take reasonable care to try and identify measures. And that's not to say that a transferee can simply bury its head in the sand. And the employer does have a duty of care not to make misleading statements where it is notifying measures, but there's no duty to proactively try and identify measures. So I'm going to hand over to Jane now, who's going to take us through some specific examples.
Thanks, Rebecca. So this is where you get to participate. So we've got 3 scenarios that in a moment Susie's going to help bring up with a poll. And each of these 3 scenarios is based on a case. So we're going to do the 3 polls to give you a chance to, having heard Rebecca with the overview, what you think the answer would have been in each of these cases. And then I'll run through what the answer actually was, so you can see if you got them all right and test your knowledge that way. So Susie, if you could put up the first poll, please, on salary and payroll. So the question is changing a payroll date a measure? I can see the answers coming in, which we'll share in a moment when we've got a good number of you responding. I think if you want to share that, Susie, the results. Oh, there's a bit of changing the mind, maybe, I don't know, but if we share the results, you can see that yes is the overwhelming answer there, and a little bit of hesitation at the bottom. So we'll see who's right when we get on to talk about the case in a moment. So Susie, if you could do the next poll, please, the one that says caseload. So the question here is a change in job description and caseload a measure? So there's some answers coming through, and again, I think if we share that one, Susie, we've got a good response now. Again, the overwhelming answer there is yes. A little bit more divided on the maybe and the no. So again, we'll pick that one up in a moment and see if yes was indeed the right answer. And then finally, Susie, the last quiz on this slide. So is a general reduction in manpower a measure? Interesting. Okay, if we share the results of that one, Susie, a little bit more evenly split here, but with yes still coming out on top, but not by quite such a margin. Okay, well, let's see what the answers were then. If we could stop the poll, Susie, and move on to the next slide, that would be great. So the first one then is a change in payroll date, slightly affecting salary a measure. Well, the case we're talking about here is a Scottish Employment Appeal Tribunal case from 2010, and it involved the sale of a care home from Ms. Todd to another entity. And Ms. Strain, who was one of the care home workers, and various other people claimed that they hadn't been consulted with properly. Now, the particular things that they said were measures which hadn't been consulted about properly were the consequence of the fact that rather than agree that the buyer would simply pick up paying from the end of the month, what happened was Mrs. Todd, who was the transferor and the seller, she paid the individuals for the first sort of few days of the month. I think the sale took place on the 4th of January or something like that. So she paid them for the first few days, and then the buyer picked up from there. And the consequence of that was, A, they got paid a little bit for the month, slightly earlier than they would otherwise have done. That had a tax consequence for some of them, which was referred to as a tax rebate, which was a little bit confusing because that wasn't exactly what it was as it transpired in the case. And there was also something which the EAT never properly understood, which is clear in their judgment, something about holiday pay as well. So these were quite small sums because they were quite low paid care worker employees. And actually there was no detriment in terms of finance. It was just a cash flow issue. And in a couple of cases, people are actually slightly better off from a tax perspective. But there was absolutely no consultation at all about this. And in fact, they didn't, the whole consultation was pretty poor. They didn't invite employees to be elected as representatives. And I think as we go through these cases, you'll see that the better the quality of the consultation generally, perhaps the stronger ground you're on if there's some sort of breach. But here, the consultation and information exercise was really, really poor. So you're probably hearing where this is going from what I'm saying. Those of you who said you thought that this change in payroll would be a measure, you're absolutely right. That's what the EAT said. This was not an inevitable administrative consequence of the transfer. The change of payroll was something that the transferor and the transferee had agreed between them. So this is one of those cases actually where it was the transferor's measure as much as the transferees. I know Rebecca said earlier, often we're talking about transferee measures, but here it was actually both parties. And one of the appeal points was that in the employment tribunal, only Mrs. Todd as the transferor had been held liable. And she appealed against that and said, no, it should be joint and several. And she won on that. So what this case tells us is that the changes have to be not simply as a consequence of the transfer, and they don't necessarily have to be negative. And perhaps slightly surprisingly, given the fact they weren't negative, the award in the first instance was 13 weeks pay, so the whole amount, and was reduced on appeal to 7 weeks pay, which is still quite high. But as I mentioned earlier, context is key, and there were comments that, you know, these were low paid employees, they were worried and concerned about the impact of this, and there was no effort to properly explain it or reassure them, and therefore it was right that the penalty was set fairly high for that, even though the changes in the EAT's words were of very limited significance. So if you voted yes on that one, well done, you were right. So let's move on to the next one. And this is about sort of caseload and work type, really. So this is a case involving Marks and Spencer's, again, an EAT decision. Marks and Spencer's had decided to outsource what they called their profit protection operation, which was basically preventing theft in stores. And the preferred bidder was Securicor, who they eventually outsourced to. And there were about 200 loss prevention investigators affected, including Mrs. Baxter. And what happened after the transfer was Securicor refocused the type of theft that they wanted the loss prevention investigators to concentrate on. And they refocused it to external, so, you know, customers coming into the shops and stealing, as opposed to internal theft from other staff. And so the change in job role was refocused, but it was still within the existing job description that they had at Marks and Spencer's. And it was also part of the findings that the reason for doing the outsourcing in the first place was that Marks and Spencer's had identified that they were sort of lagging behind in terms of their approach to theft prevention. They weren't really up there with the way most major retailers did it. And so they always wanted, whether they outsourced or did it internally, to reduce the number of thefts and focus on those which were the majority external. Excuse me. So on this one, it was held that change of emphasis was within the job description. So it wasn't a measure. There was also a complaint that they were now required to go through a different reporting mechanism for internal investigations. And again, it was held, well, that wasn't necessarily in connection with the transfer and was not a measure. So because M&S always intended to refocus things and drive up the external theft arrests, this was all found to be in the context of their business. It wasn't in connection with the transfer, and it wasn't a measure. It can be, I think, quite hard to distinguish these concepts, but as I mentioned in the Todd and Strain case, the general consultation exercise was really bad. In contrast, the one M&S did in this case, you know, they'd taken a lot of care to plan it properly. You know, it was exemplary on many levels, and so I do think that background and that context does sometimes influence these cases. If you're not sure, I think it would be sensible if the commercial considerations allow to sort of err on the side of caution and talk about it anyway. But sometimes, obviously, that the commercials dictate otherwise. If we move on to the next one. So this is a very entertaining case to read if you fancy a bit of deeper looking at this. It's actually you'll see it's in the Chancery Division, not in the Employment Tribunal or Employment Appeal Tribunal. And that's because it was about the privatisation of the dockyards. Excuse me, losing my voice. It's about the privatisation of the dockyards under the Dockyard Services Act 1986, which basically included equivalent provisions to TUPE on information and consultation. And there were 6 unions involved, and they were all implacably opposed and obstructive to the privatisation of the dockyards. They didn't want it to be commercialised, and they basically refused to engage in consultation constructively at all. And they asked for all sorts of information about the bids that were received in response to the privatisation tender. They wanted the calculations and assumptions sitting behind those. What the court did was it reminded itself, as Rebecca has reminded us, that measures are, of the widest import and include any action, step or arrangement. But mountain power projections in and of themselves are not necessarily measures. Here, it was known that the Royal Navy's requirements for the docks to be used were going to reduce anyway because their core programme was reducing. So again, that wasn't something that happened because of the TUPE transfer, it wasn't in connection with the transfer. And so where positive steps to reduce manning levels would be a measure like redundancy programmes, if you're just looking at natural wastage, a decline in the activity generally that everybody knows about, that's not a measure in connection with the transfer. The other point was when it became clear that this actually was going ahead and the Secretary of State wasn't going to back down, the union got engaged quite at the last moment and then started talking about some of these measures. And what the court said was, well, yes, consultation may change measures envisaged and it may impact on the time left for consultation if people don't get involved earlier on. So it's very critical of the union and quite interesting in that regard. Okay, we're going to do a couple more quizzes. And then I'll just briefly touch on 2 more cases before I hand over to Liz. So if we could do the first poll on this one, Susie. These ones aren't, with the exception of the first one, the other 2 aren't based on cases. So we'll all be a little bit in the dark on those. So the first one is changing a profit share scheme from the transferor to the transferee a measure? Okay, the answers are coming in. Okay, do you want to share the results of that, Susie? It's a fairly common pattern here that's emerging. So most people think yes, and then a bit of a no and a maybe. Okay, we'll see. Next one, please, Susie. The clue is in the picture. Is changing the format of the Christmas party a measure? I think we're going to get a slightly different answer on this one. Want to share the results, Susie? So we've got a resounding no and a little bit of a maybe. Okay. And the last one is about gym membership. That's a picture of a gym. I don't go to gyms very often, but I believe that's what it is. Right, is changing gym membership a measure? Okay. If you want to share the results, Susie, please. This one's much more divided, pretty evenly split, but still with on balance, a bit of a yes. Okay, well, let's see what the first one told us. So this one is about the share scheme, as we said, a profit-related share scheme. So the parties are Mighty and French, and again, it's an Employment Appeal Tribunal decision. And briefly, the facts were that the claimant, so French and others, had originally transferred from Sainsbury's, and they transferred initially to a company called Pitman Bowes, and then by the time the case came to be heard, they had transferred again to Mighty. And when they were at Sainsbury's, they had an Inland Revenue approved profit sharing scheme. Sainsbury's board would apportion a certain amount of the profits each year to this scheme, and then individual employees would be given an award, which was made up partly of Sainsbury's shares and partly of cash. And the sort of criteria for an award didn't have any element of personal performance attached to it. It was all about the company performance and some other variables. Now, Pitman Bowes did have a share scheme, sorry, did have a profit related scheme, but it didn't have any shares attached to it. It was all about cash. And there was an element of personal performance which determined the award. So they were claiming that they should have been allowed after the transfer to continue to participate in the Sainsbury's, to get Sainsbury's shares, and that Pitman Bowes and then Mighty had to operate that same scheme as Sainsbury's had. And the EAT said, well, you know, the purpose of TUPE is to protect employees, obviously, but it can't result in things that are unjust, absurd, or impossible. And as a completely separate corporate entity, neither Pitman Bowes or Mighty had any access to Sainsbury's shares. There was a suggestion from the Claimants Council they could have gone and bought them on the stock market, but that was deemed as impractical. And they wouldn't have been party to the sensitive commercial information that would have dictated the size of the pot in the first place. So it was a sort of common sense judgment, I think. And it said, but just because you can't replicate that one, you do have to give something that's substantially equivalent. And they made an interesting comment, the AT, that they would expect the union, if they're the reps, or the staff themselves, to be able to, you know, sit down and negotiate a new arrangement that was substantially equivalent with the employer. So if it's going to produce an unjust, absurd, or impossible result, then it's not going to transfer. Okay, if we look at the next one, the Christmas party. So the Christmas party and the gym, there's no reported cases on these, so we're all in the dark. And I think if you put it depends, that would be where I would be with this until I knew more about the exact arrangement. So the Christmas party, you think, well, yes, every year each employer surely decides, you know, how they're going to operate that. But if, for example, your employer traditionally, you know, brought everybody from all over the country to HQ town for the Christmas party, and they paid for travel and they paid for overnight accommodation, and the change is that the transferee is going to say, well, we'll have the party, but you've got to pay for yourself, you can see that that begins to look like a measure. Similarly, the gym membership, you know, if the level of membership changes, if it's going to be a gym that's further away, if they can't continue the same gym, you know, if it's something that impacts on the ability of the employees to benefit from the membership, then again, it begins to look like a measure. So I'm afraid those two are, until you knew more about the facts and the actual proposal, those would be a maybe in my view. Okay, and if we could move on to the next slide, Susie. Just wanted to touch finally before I hand over to Liz on a case which is about, it's an important principle. It's perhaps not foursquare with measures, but it often comes up in that context. And there were two issues. The first issue was Ms. Bernadone suffered a personal injury when she was with the transferor employer. And when she moved to Pall Mall, the issue was first, does the liability for that personal injury tort transfer? The answer to that was yes, it does. And then the supplemental question was, well, can the transferee benefit from the insurance that the transferor had for that injury? Because any employer liability insurance they take out will only cover the period post-transfer. And there was a common sense reading of Regulation 5.2, and it said that talks about, you know, the rights of the transferor, not just the liabilities, and therefore the transferor's right to benefit from that insurance policy did transfer, and the transferee could claim the benefit of it, and then that could be passed on to Ms. Bernadone. Public sector is a bit different because they self-insure, and we haven't had a case yet that we're aware of about other types of insurance like private medical, but those sorts of private medical arrangements can be very tricky because often the transferee's insurer won't accept somebody who's already covered for an existing condition, because they'll say it's a pre-existing condition and it's excluded. So we have to, those things can get quite tricky to deal with. So I just flag it as something to look out for. So I'm now going to hand over to Liz for the pensions part.
Thanks, Jane. So where changes are being proposed in relation to the transferring employee's pension provision following a TUPE transfer, and this will also feed into the mix when identifying your measures. And I think it would be helpful here to just take a step back and summarise what happens in relation to pensions on a TUPE transfer, because that will inevitably impact on whether the receiving employer looks to change pension provision for the transferring employees, and how that then impacts on the TUPE information and consultation obligations. So just in terms of a reminder, there are, in very broad terms, two types of pension scheme which might be available to the transferring employees before the transfer. And the reason I flag this is because each type of scheme is treated differently for the purposes of TUPE. So the first is an occupational pension scheme. So what do we mean by this? So essentially, this is a pension arrangement set up under trust to provide retirement benefits for employees. And I think it's fair to say it used to be the case that this would be an employer's own pension scheme arrangement, but it's no longer exclusively the case because many employers now make use of multi-employer arrangements, so lots of different employers that aren't associated taking part in that occupational pension scheme. And well-known examples of that include Nest and the People's Pension, but many master trust arrangements, and that is an occupational pension scheme. And in terms of TUPE, where an occupational pension scheme is provided to the transferring employees before the transfer date, TUPE operates so as to carve out the transfer of rights, obligations, liabilities, duties in relation to that occupational pension scheme from the transfer. So that occupational pension scheme remains with the transferor. People become deferred members of that scheme, and that's sometimes referred to as the TUPE pensions exclusion. Occupational pension schemes can provide either defined benefit or defined contribution benefits. But key, as I've mentioned, is that rights relating to that don't transfer, but instead there are minimum legal obligations on the transferee to put in place minimum standard pension scheme provision following that transfer. So it can look and feel quite different to what was on offer before the transfer, but there does need to be that thought process as to, if there is an occupational pension scheme on offer before the transfer, what the transferee is going to do after that. By contrast, and the next slide please, Susie, is the position for contract-based pension schemes. So these are often known as personal pension schemes, and they are often provided through an employer, and then they're called group personal pension schemes or GPPs. But they're different to occupational pension schemes because they're a contractual arrangement as between the employee, the member of the scheme, and the provider, so usually an insurance company, and that includes GPPs. So essentially it's a collection of individual policies between the provider and the employee. And these types of schemes exclusively provide defined contribution benefits. So they're very common, but actually so are occupational pension schemes. So again, it's that due diligence to check what's on offer before the transfer to decide what's going to happen. And key here is that rights relating to personal pension schemes do transfer, as would be the case for any terms and conditions as part of a TUPE transfer exercise. So, for example, if there's a particularly generous employer contribution to that personal pension on offer before the transfer, let's say a 10 or 15% contractual right to employer contributions, that is going to be a right that will transfer in respect of those transferring employees. So the next slide just gives a summary of the two differences and really allowing you to just have that thought process, what's on offer and what do we need to think about in terms of what we might be doing after the transfer in terms of pension provision. Moving on to the next slide. So what is the measure for pensions purposes? Well, as I've mentioned, there's this pensions exclusion in TUPE that says that rights, obligations, liabilities relating to that occupational pension scheme, they're not subject to that automatic TUPE transfer principle. But actually that's given rise to a question around whether changes relating to an occupational pension scheme are a measure for the purposes of TUPE information and consultation obligations. We had an employment tribunal decision from the early 1980s called Natake, involving the transfer of a cinema, and there was a very late in the day information and consultation process, and a claim of failure to consult resulted from that, particularly allegations that there'd been no informational consultation as to the loss of ongoing occupational pension scheme benefits. So this would be a common situation even now, as I've mentioned, because that occupational pension scheme remains with the transfer rule. And here, interestingly, the tribunal held that changes to occupational pension scheme benefits would not be a measure for this purpose because of this pensions exclusion I've mentioned. 2 points on this. First, it was an employment tribunal decision, so it wouldn't be binding on other tribunals or courts. But I think the key point really is I think this was wrongly decided. In terms of the general purpose of TUPE, the case law that we've seen more generally since then, I think it's very unlikely that a tribunal would decide that in the same way now. Pensions changes are clearly something that's going to be very important to employees and their representatives, and something on which a union or representative will really want to be consulted with and will want to understand those changes. So, best approach, definitely assume that pensions is going to be included in relation to measures, and that's the case for any kind of pensions change. Okay, so moving on to the next slide. So what I've just said really in a nutshell, and I think, you know, even if we're having very small changes, so what might happen in relation to a group personal pension scheme is that the transferee can't provide exactly the same one following the transfer. But even if it's going to honour those contractual obligations to provide the same level of employer contribution, I would expect that even a change of GPP would be a measure, and that you tell the employees and their representatives about that, or the transfer orders on the transferee's behalf in the way that Rebecca's described. And obviously, if more radical changes are being made to the pension because, for example, occupational pension schemes were offered before the transfer, again, that would be definitely something that should be considered to be a measure and should be treated as such. So moving on to the final point I wanted to cover here before handing back to Rebecca, is a case called HAGEN ICI Chemicals. And although this was a pensions decision, looking at pensions changes, it does have wider application in terms of the information that's provided as part of an information and consultation process. And this was in relation to a group of employees who were subject to a TUPE transfer from ICI Chemicals, part of its engineering division, to a company called Redpath Engineering. Now, statements have been made by ICI as part of the TUPE information and consultation process as to the likely pension provision that would be offered to the transferring employees following the transfer. And they'd specifically been told that pension provision would be broadly comparable, broadly similar to ICI's own pension scheme. Afterwards, it became apparent that actually the pension provision hadn't been as had been suggested by ICI, and a tribunal claim was brought. And the court in that case held that the transferring employees had a claim for negligent misstatement. They'd been given misleading information about pensions in anticipation of that TUPE transfer. And that was the case, and ICI was liable for that, even though that information had been honestly given. So key takeaway here is that employers do have a duty to take reasonable care in making statements, particularly in a TUPE transfer context. There are lots of reasons for that. But you know, the transferor has access to information relating to the transferring employees that's been given to them by the transferee. Statements are likely to carry significant weight with those employees. And so in summary, information given in connection with a TUPE transfer really should be as accurate as possible, because if they are misleading, that could result in claims. So that's all I wanted to say on pensions and measures. So I'll hand back now to Jane and Rebecca for the final section.
Thanks, Liz. That was really helpful. So now that we all understand measures, I thought it would be helpful to round off the session with some practical notes for when we're managing consultation on measures. First of all, I mentioned earlier that TUPE requires consultation with a view to reaching agreement on the employer's measures. It's the role of the employee representatives to listen and share information with employees regarding the measures which are envisaged, and also then to be the voice of the employees presenting their views and feedback to the employer in response. As we saw earlier, TUPE requires that this consultation is carried out with a view to reaching agreement on the measures. But importantly, I just wanted to note that the employee representatives don't have any right to veto measures. So what needs to happen is that the employer should give due consideration to any feedback that they get from the representatives, but it's not actually obliged to accept the employee's proposals. And the second point to mention is that the extent of the measures which are envisaged is important to determining the timing of the consultation process. So although there's no set time period for consultation under TUPE, it's got to be carried out in good time before the transfer. And what's in good time is essentially going to depend on the extent and nature of the measures to be consulted about. So it's important that that's given some thought early on so that the parties are clear on what's an appropriate time frame from the consultation process. And there's a note on the slides to highlight cooperation. And this is basically thinking about cooperation between the transferor and the transferee during the consultation process. So although the duty to carry out consultation is primarily a matter for the transferor, we've seen today that the focus of the consultation is generally going to be around discussion of the transferee's measures. And it's common in practice for the transferor to invite the transferee to attend certain consultation meetings, so it can give them an opportunity to present to the employee representatives directly, and also to answer any Q&A on the measures directly as well. And generally, we find that a well-run process is going to be a collaborative one, so it's certainly worthwhile the parties getting together to think about that at the outset. And the final point that I wanted to note is in relation to further consultation. So it's important to remember that communicating measures as part of the TUPE consultation process is often only the start. If the measures involve workforce restructuring or redundancies or changes to terms and conditions or anything like that, then it will also usually be necessary for full consultation to be carried out after the transfer in order for the transferee to implement the proposals that it's communicated. And in some cases, that might include a requirement for additional collective consultation. And I just wanted to note that because where it's known early on that that's going to be the case, it can be factored into the process. And in some circumstances, it's also possible for collective consultation on redundancies to run side by side with the TUPE consultation. So again, those are sort of factors to be thought about at an early stage, that they can be factored in to achieve a smooth consultation process. And on that note, I mentioned earlier that identifying potential measures that the transferee would like to take is all well and good, but it's important to bear in mind the extent to which TUPE might actually prohibit or restrict the employer from implementing measures in certain respects. And that includes where measures involve changes to terms and conditions of employment. And I just wanted to flag that we're going to look at that at the next session in this series, which will be early in the summer. So do watch out for a date for your diaries on that. We'll share something shortly. And on that note, I think we've got a few minutes left for questions. So I'll just hand back to Jane and she can tell us what you've all been asking.
Thanks, Rebecca. So there's one I can deal with quite easily, which is about what happens if your measures change or new ones come to light. Well, it's an ongoing obligation up to the point of transfer. So if something new does come up, then you're going to have to pick that up, and you could be criticised, subject to a penalty if you don't. There's one, Rebecca, it'd be good if you could pick up. It's how does TUPE affect a fixed term employee who's going to reach the end of their contract before the transfer, where there's going to be a change of provider before the expiry of the fixed term contract? I think, sorry, go on.
Yeah, okay, I was just going to say in that circumstance, if the fixed term is actually due to expire before the transfer is due to happen, then the individual won't be an affected employee for the purposes of consultation. So there won't be an obligation to inform and consult in respect of that individual. But having said that, it is common for employers to bring them within the process in some respects. So either to have a separate conversation with them just to explain what's happening to their colleagues and why they're not included with it, or even to bring them in within the process, potentially because there might be an opportunity for the contract to be extended, in which case they would become affected. So just to be clear about what the status is for them at the outset and how that will be dealt with, and bear in mind that it could potentially change leading up to the transfer date. Yeah.
And then very briefly, there's one, is there a legal minimum time frame that we need to consult on the TUPE if there are no measures with about 100 employees? And I think I would say the cable one said it's got, the the cable people got criticised, the case that you mentioned about needing to leave time for voluntary, because they tried to say that a factory shutdown of 2 weeks in the summer counted towards that period. So I don't remember off the top of my head if they gave a particular time frame from that case. Rebecca, can you remember?
No, I don't think there was a particular time frame. It was just the principle that you can't assume that just because there's no requirement for consultation that it can be dealt with in a few days. It's got to be in good time still. I think we generally work on the basis that if there's absolutely no measures, which is quite rare, but we sometimes find, particularly if there's an intra-group process, then the shortest time frame that you should allow for consultation is about 2 weeks, and generally going upwards from there. The more time available, the better. For a consultation process that does have significant measures, we'd normally expect 3 months to be a reasonable period. So that kind of hopefully gives you a bit of guidance and time frame for working out what sort of falls within the middle of that.
Okay, thanks. Well, we've slightly overrun, so I'm going to call it to a close there. But for those of you we haven't managed to get to your question, we will come back to you afterwards. And thank you for putting your names in there, because we can see who's asked a question and get back to you by email. So I'd like to say thank you very much to Rebecca and Liz and to Susie for doing all the techie stuff behind the scenes. I hope that's been helpful to you all, but obviously you've got our contact details if you've got any other questions that occur afterwards. Do look out for that next session on changing terms and conditions, and please do fill in the feedback form if you get a chance when you receive it by email shortly after this session. So thank you very much for joining, and enjoy the rest of your day.